and you cannot establish a public office which can only be done by the Public Service Commission and make it superior to a constitutional office under Article 15 of the Constitution. That is my issue with that particular office. I want to go to the second office. The office of the Chief Administrative Secretary. Honorable Speaker, Article 152 of the Constitution is very clear. It is the article that establishes the cabinet, and the cabinet is clearly composed of the president, the deputy president, the attorney general, and the cabinet secretaries. Okay, I give a specific number of cabinet secretaries. Honorable Speaker, the Constitution goes ahead at Article 155 and establishes the office of the principal secretary. Honorable Speaker, the architect of the Constitution, if you read it logically, Honorable Speaker, you will see that from the cabinet secretary, the second in line is the principal secretary, with distinct functions. Distinct functions. I want to read for you one of the functions of the principal secretary under Article 155. Article 155 of the Constitution. There is established the office of the principal secretary, which is an office in the public service. Which is an office in the public service. Honorable Speaker, I'm looking for the functions of the cabinet of the principal secretary. Honorable Speaker, 155, yes. 155, no, my eyes are failing me. Okay. Okay, add 155 sabbatical 2. Each state department shall be under the administration of a principal secretary. Under the administration of a principal secretary. The Constitution did not contemplate that at some point in time a House of Parliament would sit and purport to establish another office outside the Constitution, to be somewhere between the cabinet secretary and the principal secretary. And the principal secretary. There is nowhere. The Constitution, the drafters of the Constitution could not have imagined that at some point in time a parliament would create an office outside the Constitution. Would create an office through a statute, an ordinary statute.
Order, there's a point of order from...
But I am also... I'm also a point of order.
It's on a point of order.
Use the mic.
It's on a point of order.
Thank you very much, Honorable Speaker. May I draw the attention of my minority leader to Article 132, Sub-Article 4 of the Constitution of Kenya, which provides that the President may perform any other executive function provided for in this Constitution or in a national legislation, and except as otherwise provided for in this Constitution, may establish an office in the public service in accordance with the recommendations of the Public Service Commissioner. While he's at it, may he address that particular point? That's the Constitution of Kenya. Thank you.
And let me educate my good friend, the Honorable Karoli. The same Constitution under Article 234, Sub-Article 3A. Okay? Let's go to Article 234, Sub-Article 3A. And it says clauses 1 and 2 shall not apply to any of the following offices in the public services. One is state offices. In other words, the Public Service Commission cannot establish a state office. If you go to this bill, The Chief Administrative Secretary is characterized as a state office. Honorable Speaker. Honorable Speaker. I think he is now properly educated. Honorable Speaker. Honorable Speaker. There is no way. There is no way. An office.
Wind up.
Okay, I'm winding up. And I'm very happy that, Honorable Speaker, that you've given me this kind of opportunity to address this issue.
I've overindulged you.
You've overindulged me. Honorable Speaker, if you look at the functions of the Chief Admin Secretary in the bill, Honorable Mbui again help me. Okay. Very, very briefly. The functions of the Chief Admin Secretary. He or she shall be responsible for, among other things, responding to issues relating to the portfolio assigned to the office, liaising, representing the Cabinet Secretary at any meeting, performing any other duties assigned by the office of the Attorney General and the Cabinet Secretary. In other words, a plain reading of this bill tells you that the Chief Admin Secretary shall be responsible to the Cabinet Secretary. In other words, he or she shall not be responsible to the Principal Secretary. So in short, you are creating this office above that of the Principal Secretary. He is essentially a Deputy Cabinet Secretary. And you are creating this office outside the Constitution. Mr. Honorable Speaker, this is an arena that we should be careful not to venture into. Because if we do so, we shall be setting ourselves as a house to very needless litigation. And you know the verdict, Honorable Speaker, without really preempting. These ones, if it goes to any court, will be declared unconstitutional. So why should we waste time? Why must we waste taxpayers' time deliberating on these issues which are very clearly unconstitutional? Therefore, I want to plead with you. I want to urge you, Honorable Speaker, that you discontinue this debate and retreat to make a considered ruling on the issues I have raised before the provision of this motion or bill can proceed.
Yes, Carol.
One way or the other. With those remarks, I rest my case. Thank you.
Thank you very much, Honorable Speaker. Again, there's a misconception here. If you look at Article 234, it took me a bit of time to get it. The powers of the public service, the disciplinary powers of the public service, the power to hire, fire, and discipline, are what are restricted in terms of how they exercise those powers in relation to state officers. Because there are special procedures for state officers when you exercise those powers as a public service. And I can give you an example. I was the first chief of staff in the Republic of Kenya. When we created that office, there was no power. But the president had the power, executive power, to organize his executive office. So did the prime minister. So there are offices in a presidential system of government that are created not necessarily by law. If you check the history of chief of staff in the United States, the first holder was a presidential appointee by executive order. And over time it has gained currency. Simply because in a presidential system, such as the one we have, there are officers that cannot exercise both what you call bureaucratic power as well as political power. A permanent secretary cannot interface in a presidential system with parliament. So in a presidential system such as the one in the United States, the presidents have their chiefs of staff who can exercise both bureaucratic power as well as executive power and interface politically with Congress. And that power is vested in the president. And what is quoting under Article 234 limit the authority of public service in terms of hiring, disciplining, and directing the state officers. But it does not extend, it does not limit the power of the president under Article 132 to establish officers in the executive as he so wishes. Thank you, Mr. Speaker.
Murugara hold Jared Okello.
Yes.
On the same issue. Murugara, you are the chair of the committee. Hold. I'll come back to you.
Honorable Speaker.
Hold your horses, Murugara.
Honorable Speaker,
even as I align myself with the sentiments as expressed by my brother Honorable Wandayi, I did read the ruling by the High Court on this same matter, Honorable Speaker, with a tooth comb, because I needed to understand the gist of this entire issue. And one thing that caught my attention, Honorable Speaker, is what the court said, that we are being governed by a constitutional dispensation of the year 2010. And this constitution went into details as highlighting these offices, some of which are now under question. And one fundamental issue that these judges raised is that the position of cabinet secretaries, chief cabinet secretary, chief administrative secretary, was going to be a person just between the cabinet secretary and the principal secretary. So by inference, chief administrative secretary is a boss to a principal secretary. And Honorable Speaker, what the court said that we are still not addressing holistically is that if Kenyans thought that that office was going to be as important as this House would want to make it, the Kenyans would have put it into law in the Constitution. And the court went on to say that if indeed this position will be as important, Kenyans will have to have a say on it by way of a referendum, Honorable Speaker. Why is travel a very important consideration in enactment of these offices, Honorable Speaker? So even as we retreat to come up with an in-depth ruling, as you have always done before, let us try to look at the participation of Kenyans as infusing this office into law, Honorable Speaker. Otherwise, we were so embarrassed as a House by the decision of this court, or of our courts, and I don't want this House to be always subjected to another round of embarrassment each time we create laws here. Honorable Speaker, we don't make laws in vain. And therefore, let us go deep and look into this. I know there are people who are angling for jobs. Those who campaigned for UDA or Kenya Kwanza by extension. And they are so desperate to have something in their name. But let us do things according to the dictates of our laws and not overreach and hence face embarrassment in our courts of law, Honorable Speaker. I thank you for the opportunity.
Thank you, Mr. Speaker.
Tedious repetition. I think
Mr. Speaker, this office, historically, I can remember I was in government when the Constitution of 2010 was in process. Historically, this came from the office of then Assistant Minister. That's where this all comes from. And what the Constitution at that time, the argument at that time, that often it was found that the assistant ministers really didn't have specific jobs that they were doing. As permanent secretary, we are always asked without much guidance that to just ensure your assistant minister has something to do, assign them jobs to do. And therefore, the argument that came when the Constitution was coming was basically that this is not necessary, and therefore that position of the assistant minister was removed. And that is how later on, after the Constitution had been in place, the new government was being put, then it was felt that we needed chief administrative secretary.
What you are saying is incorrect. I was an assistant minister for 5 years, and my letter of appointment from the president specifically listed out what my duties and responsibilities were as an assistant minister.
Basically, those duties, Mr. Speaker, with all due respect,
minister never operated as a wing of the minister.
With due respect, Mr. Speaker, those actually were just to assist the minister, basically all of them. But let's not go into that argument. Now, when we come to this, Mr. Speaker, if you look at the positions that they're supposed to do, if they're going to liaise with the Parliament, or this Parliament, every time we have had to interact with, there's been we have been very clear that we need to liaise with the Cabinet Secretary. Now, this position is creating another another level. Mr. Minister, if you're saying they are going to alliance with the county government on matters of concurrent mandate, Mr. Speaker, we have the Intergovernmental Relations Technical Committee, whose job is basically that. So again, that is not. Then providing interministerial and sectoral coordination. We have the office, like in this case, the cabinet secretary who is actually dealing with that matter, whole cabinet secretary. So once again, why are we creating this position? Mr. Speaker, representing the cabinet secretary in the meeting, that actually is where the issue started. And so we are just going backwards. So Mr. Speaker, I just wanted to add that we are actually going backwards in terms of our constitutionalism. So what we have actually changed in 2010, we are clawing back and bringing them through statutes. And I think that is not, I'm not a lawyer, but I don't think that is very proper.
You done? Morogara? Yes, Chepkonga.
Thank you very much, Honorable Speaker. In order to have located this matter properly, I expected the minority leader to have quoted extensively from the case law. This matter has been litigated upon, Mr. Speaker. He knows the decision of the court in Kenyatta 2, when this position was declared to be unconstitutional. It was declared to be unconstitutional because there was no law that established it. In fact, the advice from court at that time, Mr. Speaker, was go and pass the law in Parliament. What they decided was not to pass the law. Article 94 of the Constitution, Mr. Speaker, which I'd like to aptly read to my very good friend, the Honorable Wandayi, the minority leader. If you read Article 94.2, 94.5, it says no person or body other than Parliament has the power to make provision